So good evening, friends. Welcome to all of you to this special session. We wanted to actually discuss the DGPSI as a framework, and along with this DGPSI AI. As most of you are aware, in the IDPS of 2025, we actually announced this DGPSI AI, and we also released our book on DGPSI AI. And the DGPSI itself has been in existence now for the last 2+ years. But recently, of course, now that the rules have come, there will be a greater level of interest in the organizations for taking the first steps in implementation of DPDPA compliance. And obviously, as of now, DGPSI is the only framework which is directly addressing the requirements of the DPDPA. Though we have been talking about DGPSI for a substantial time, it appears that there is a large section of the professionals who may not be aware of the DGPSI. Now, I don't know whether it is our inability to reach out or whatever is that. This particular feeling that DGPSI is not properly appreciated or recognized at some levels came up because the government of India recently released that India AI guidelines. This India AI guidelines made statements, all of which are things which we are already doing in DGPSI, particularly the DGPSI AI, like creating a framework and all that. All the recommendations of this committee are already under implementation by the DGPSI system. However, the committee chose to make references to everybody other than the DGPSI. Of course, it could be due to ignorance or it could not be, whatever it is. So I felt that there is a need on our part to actually reach out to the professionals and discuss the DGPSI. Also, I had a group of people who recently attended the CDPO program conducted by FCRF, which is our Dr. Triveni's firm. And in that group, a discussion came about DGPSI, and I had promised them that we will have a separate session for them on DGPSI. So the reason for this particular program is basically because of my commitment to the people who had attended the CDPO training of FCRF. Though FCRF is a different entity, it is not connected with FDPPI, except that Dr. Triveni is a friend. Okay. So I thought that along with that, we will also address some of the concerns expressed by people on LinkedIn about DGPSI, whether it is a robust system, can it stand on par with ISO 27701 or any other NIST or such frameworks. Of course, we are not saying that FDPPI is as big as ISO or something like that, but it doesn't matter. It doesn't matter whether the FDPPI is as big as ISO or not. If the framework DGPSI is better than something which is available from other sources, I feel DGPSI should be recognized. So that is where we feel that some people have a sort of blinkers and say that unless it comes from the ISO stable, nothing is good. I would like the professionals to go through this DGPSI. Recently, we made a comparison between DGPSI with the ISO 27701 2025 framework. we find that DGPSI covers all the controls which are there in this new framework, while the reverse is not always true. And when I say ISO 27701 does not cover everything which is there in DGPSI, it does not mean that ISO 27701 is faulty. ISO 27701 was not developed for DPDPA compliance. DGPSI was developed for DPDPA compliance. So therefore, when we look at DPDPA compliance, DGPSI obviously comes out superior than any other framework. I don't think there is anything more than that when I say that ISO 27701 does not fully cover what DGPSI covers. Anyway, I would leave it to the professionals to take a view on this. In fact, me and Ramesh are thinking of actually introducing a training program sooner, if possible, as a combo program which will teach both ISO 27701 and DGPSI to the same group of people so that they will be able to appreciate both and also make use of both frameworks when it is required in their job profile. I think we will work out on the program maybe in a month or so. And additionally, we are also planning to elevate this DGPSI program. We have a program called C.DPO.DA, that is Certified Data Protection Officer and Data Auditor, in which we are covering the data protection law as well as the technology issues and then the audit issues, okay, including this DGPSI framework. All that is being covered in the CDPO-DA. Now, we want to actually introduce another elevated training program entirely for the data auditors. In fact, I hope we will be able to launch that program probably around the privacy day, next privacy day, which will be the end of January, because anyway, December is not an ideal month for any new programs. So you can actually mark, I think it will be 27th January, perhaps a day here or there. We will be launching a program for independent data auditors. Most probably that first program will be in Bangalore. Anyway, we will discuss internally. We will try to have a physical program for about 20-25 people in Bangalore and or perhaps in Hyderabad. We are planning some activity in Hyderabad, so we may have it in Hyderabad. It will be the creating a new set of professionals called independent data auditors. Now that the rules have already been released, in the next 1 year, or say 1.5 years only you can take, there will be need for the data auditors and companies will be scouting for such data auditors. So probably we will be in time for that. These are some of the developments which I wanted to share with you as far as FDPPA is concerned. We will see how it goes through. Please keep in touch with us, probably on the LinkedIn or on our websites, naavi.org, as well as the FDPPI website. Okay, now let us come back to this DGPSI within the available time. Let me try to introduce to you why this India-specific and made in India framework is something which we need to take note of. I have added this made in India specifically because I personally have that liking to do everything indigenously. Anyway, now, as we all know, DPDPA non-compliance is a 250 plus crore rupees risk. In fact, basically, we are looking at it as a risk management for an organization. Whichever organization is using personal data, they will have to actually look at this particular risk. Maybe we can say that it is 1.5 years from now before the penalties will be levied, but to have a compliance in an organization, I think a minimum of 6 months is required. Okay, maybe some organizations will require more. So 1.5 years will be found to be completely insufficient by the time we cover that. And by May 13th, 2027, we will be having a rush for companies to work on the compliance, and they need to look for DPOs, they need to look for data auditors, they need to put in place the consent management system. All that will be mandatory, failing which they will be exposed to the uh, possibility of DPB, Data Protection Board, threatening the companies with possible penalties. I'm sure that the Data Protection Board will not like to harass companies, and they will give enough time, perhaps even beyond 1.5 years also, by just providing by making use of the provisions of the voluntary undertaking. But still, companies need to uh, take steps so that they are not at the mercy of the Data Protection Board. So they should try to get themselves ready. Now, this compliance is a techno-legal compliance. Therefore, it requires a lot of interpretation of several concepts. And therefore, it is not very easy. In fact, all of us, we know that this particular act, DPDPA, did not use the term privacy anywhere. It restricted itself to a system of protection of personal data. It only defined what was personal data, but it did not talk about privacy. That is why at DGPSI forum, we never talk of, or we more likely, we don't talk about privacy by design. We talk about compliance by design, because privacy is not defined in DPDPA. Though this act originated from the Puttaswamy judgment, the Supreme Court also did not want to define privacy fully, and therefore they talked about information privacy. And the government also was clever. They also said, if the Supreme Court itself does not define privacy, why should I define privacy in the law? Those of you who have been following these developments know that in the year 2006, the government of India had brought a particular legislation called Personal Privacy Act, in which they had, I think, defined privacy and then went about saying what needs to be done for privacy protection. But that act never became a law, bill never became a law. This time the government was very clever. They did not put in a definition of privacy. They talked about personal data, how it has to be handled by a data fiduciary. But they used the term fiduciary. And by using that, I think they have actually bound the industry in a very tight leash, because any organization which determines the purpose and means of processing is the data fiduciary. But they have not used the word data controller. They used data fiduciary, because fiduciary means a trustee. And a person who is a trustee and is given the responsibility for managing the affairs of the beneficiary, he is expected to take decisions which are for the benefit of the beneficiary. So if you say that privacy is paramount for the beneficiary, then as a fiduciary, you have to take that into account. So what the government did was that, without saying that this is a Privacy Protection Act, by giving an nomenclature of a fiduciary, they've actually broadened the scope of responsibilities of the data fiduciaries and brought in ethics into the law, because the trustee is supposed to act ethically. When we say ethics, ethics goes beyond the written words in the law. So government has been very clever in bringing in the word fiduciary, though of course we have to credit Justice Sri Krishna for introducing this concept of fiduciaries, but that was retained. At any point of time, government could have just changed it into controller. Fortunately, they did not do it. They retained the word fiduciary, and because of which the responsibilities of the organizations have become very, very high. So this concept of fiduciary is alien to the GDPR scenario where the organization is a controller. And in fact, to be a controller, I feel it is easy. Okay. Now, if DGPSI is not available, then the companies today will have to look at the other internationally available frameworks, including ISO 27701 or NIST privacy framework, etc. But none of these frameworks are exactly capable of providing you the guideline for the DPDPA compliance. So therefore, if you are trying to use these foreign frameworks, lot of customization has to be done. I'm sure that customization can be done if you understand the DPDPA. You can customize, but while doing the customization, you may make certain errors. Instead of that, DGPSI actually provides directly the requirements of compliance of DPDPA. So therefore, there is a situation more like this. There is no other alternative kind of a situation as far as DGPSI is concerned. Now, I can assure you that DGPSI fully covers ISO 27701 2025, and the DGPSI AI is a further innovation that takes compliance of a data fiduciary well past the contemporary thinking, including the latest India AI guidelines. Because this DGPSI AI recognizes that the problem of AI is more with the deployers. Internationally, all the AI governance principles are all geared towards the developers, and the deployer, who is a data fiduciary, has very little say guidance on how to manage a situation when he himself uses AI, or one of his data processors are using AI. So that's why DGPSI AI is a very important development. It is ingenious, it is innovative, and I think it is indispensable to meet the twin challenges of DPDPA and AI, which have come together. Now, very briefly, DGPSI has two versions. One is called the light version, which has got 36 model implementation specifications. This term model implementation specification is similar to your controls in the ISO standards. Basically, these are the requirements. This DGPSI Lite focuses on DPDPA compliance without any frills. This is ideal for an SME. So it is easy to perhaps comply with it. DGPSI full version is something which is good for a larger organization because it includes lots of governance issues. Now, DGPSI full version has about 50 model implementation specifications, and it covers Information Technology Act requirements related to personal data, then the draft guidelines of BIS, and today even the Telecom Act or the Consumer Protection Act, the Bharatiya Nyaya Samhita, all of them have got some legal provision related to personal data, and DGPSI full version tries to bring the compliance requirements of these other laws also into the particular framework. Plus, this uses several innovative provisions, such as the distributed responsibility and classification system and other things. So therefore, it is something which is a good tool for implementation and later on for audit and certification also. Now, this DGPSI AI is configured as an extension of the DGPSI. Mostly it should go with the full version because the objective of the light version is actually limited. DGPSI full version along with DGPSI AI may be considered as a more robust framework. This DGPSI AI has 6 core principles. The DGPSI full version and the DGPSI has got 12 foundation principles. Now, this DGPSI AI adds another 6 principles and 9 implementation specifications for the use of the AI deployers or data fiduciaries. While working on this data fiduciaries requirements, we also developed 13 implementation specifications for AI developers, which needs to be mandated in the AI purchase contracts. Our objective was not to define any framework for the developers, but while talking of the requirements of the deployers, we had to actually provide some kind of way by which the contract for supply of an AI system, which is ultimately used by the data fiduciary for processing personal data, needs to be fortified with some requirements. And that is where we included these 13 implementation specifications, which also I will briefly talk about in the end. Now, the model implementation specifications, or MIS, as I said, is a recommended compliance measure. And this 50 model implementation specifications are relevant for calculating or say arriving at the assessment of the maturity of compliance in an organization through what is called a data trust score. Again, this term data trust score was introduced in the earlier versions of Indian Data Protection Act. It is not there in the GDPR. It was brought in the PDPP 2019, even in 2018, and then carried through 2019. But subsequently, the government dropped this provision of data trust score, but we thought that it is a great provision and we should retain it under DGPSI. So in DGPSI, when an audit is done, the auditor also gives his views on the maturity of the compliance, and that will be translated into a data trust score. Okay. Now, MIS, we have kept some flexibility. We can say that it can be reduced from the model implementation specifications to adapted implementation specifications, which will be done through an additional document called deviation justification document. This deviation justification document is somewhat similar to the statement of applicability which you use in the ISO audits, where you have got the table A controls, and if you don't want to use all the table A controls in a particular situation, you create the statement of applicability. And similarly here we have got the MIS, and for some reason the particular organization doesn't want to implement all the 50 implementation specifications, then we give them an option that at the highest level at the board, create a document called deviation justification document. Tell us that you are absorbing the risks in respect of those model implementation specifications you have bypassed. And then the implementation team, which is internal, as well as the auditors, will continue with the rest of the accepted model implementation specifications. However, when we calculate the DTS, we still go by the model implementation specifications. So those organizations which actually use this flexibility for reducing their compliance obligations may lose out in the DTS score to some extent. Okay, and the deviation justification document has to have a proper logic built into it. It's a conscious risk absorption decision by the management. Because of that, the data protection officer is to some extent not burdened with the decision of leaving out certain model implementation specifications. Now, this whole system is coming under our FDPPI organization, which is a Section 8 company. It's a non-government organization of data protection professionals. In fact, this is to be developed more like the Chartered Accountants Association. FDPPI is not like NIST made by from the government. It is not like ISO. It is not even like high trust, where the industries have come together, put in their money, along with that their vested interest, and creating an organization of standards. Whereas this FDPPI is an organization of the data protection professionals. We don't have any vested interest of the type which would be there if the organization was funded by the companies for its day-to-day business. Now, FDPPI accredits individuals with that CDPODA program, and these accredited CDPODA or Certified Data Protection Officers become the lead auditor kind of persons. And there will be also organizations which will be employing these lead auditors and conducting the audits. And FDPPA has developed some system by which you control the audit. Okay. Now, one of the core differentiations which this DGPSI brings in is that DGPSI recommends team ownership of the compliance program in an organization. Say, in the case of an ISO 27001, it is owned by the CISO. ISO 27701 PIMS is maybe owned by a DPO. DGPSI, where we say it should be led by a governance committee where all the stakeholders will be represented. Stakeholders like the chief marketing officer, chief finance officer, CRO, and even the compliance officer, the legal person, HR person. They should all be part of this governance committee, and they should own the DGPSI implementation fully. There will be a DPO, of course. DPO is the person who will be implementing it. He will take the assistance of the CISO. All that is there. But ultimately, it is this governance committee which owns the DGPSI. I hope that this will enable better harmony at the CXO level in pursuing any conflicting goals which may arise within the compliance framework. So with this basic...
We lost the audio.
Pardon?
Naavi sir, we lost the audio.
You lost the audio.
Oh, we are able to hear Murugan sir.
Okay, then Murugan, why don't you check your speakers? Others, can you confirm that you are able
to...
Yes, sir, audible.
Audible.
Everybody is able to.
Very good. Please check, Murugan, please check the speaker. Sometimes it happens to me also.
Yeah, got it, sir. Got it, sir. Thank you.
Yeah,
very good.
Sir.
Okay, now we will go deeper into this framework. Now, I will first look at the principles. There are 12 principles for DGPSI and 6 principles for DGPSI AI. I would like to first introduce these principles. I may not be able to go through every word of what is written here for want of time, but I will give you the flavor of the principles. Now, the first principle behind DGPSI is that process is the focus of compliance. What I mean by this is, though compliance is an enterprise level responsibility. See, and in the case of ISO, you may choose a particular division and say my scope is only related to this division. But legal compliance cannot be compartmentalized like that, because if there's a legal liability, the legal liability will hit the company. Even if one person somewhere in the branch office makes a privacy related non-compliance of law, that liability will have to be taken by the organization. And particularly because there is in the background a law called Information Technology Act. If there is a data breach, it will not remain as only something under DPDPA for which 200 crores, 250 crores penalty will be levied, which the organization will pay off. But when there is a data breach, it will automatically become an offense under Information Technology Act 2000. And there, Section 43 gets invoked. When Section 43 gets invoked, the individual data principals can claim compensation. Along with that, 43 brings in Section 66 of Information Technology Act, which is a criminal section having 3 years of imprisonment. And in the ITA 2000, it also provides that any offense of a company can be escalated to the officials, such as persons who are in charge of business, directors, company secretaries, and other things. So therefore, the non-compliance of DPDPA can lead to personal criminal liability for the executives. So these are all enterprise level compliance issues. Unlike, say, for example, that's why I say that in ISO you may define a branch, define a system and say this system I am going to audit. Here, being a techno-legal audit, the enterprise will be responsible. But still, for compliance purposes, what we do is we try to look at the enterprise as an aggregation of multiple data processing activities in the organization. We identify each process because each process has a purpose. When we talk of process here, I'm talking of a technology process which takes personal data, that personal data which comes under DPDPA, it collects, stores, modifies and processes it. It may disclose, it may destroy. So whatever it does with the personal data, that is a technology process. Then there is a purpose for each such process. So one particular purpose, there will be one particular process. We identify that. Like that, we try to find out, say, 50, 100 processes in an organization and try to work on compliance in each of these processes. Ultimately, they will get aggregated into a common inventory system and other things. When you do this process-based compliance approach, what happens is, for the particular process, I can define the requirements of data. So data minimization gets integrated there. Data retention gets linked to the process and the corresponding purpose. Even data access of who should access that particular data is in a way linked to the purpose and the process. So if I have got an inventory of data for a particular person, I have got, say, 25 personal data parameters. Process one may require only 3 or 4 such parameters, and the persons who are given access to this process will have access only to the 3 or 4 data parameters. That kind of distinction is possible if we look at the process as the micro element under which you look at the compliance, and then later on add the multiple processes and say the company is either compliant or non-compliant. Another aspect which this process-wise bifurcation helps us to do is, sometimes it is difficult in this particular aspect. Even the law is deficient, because when we, in the law, we look at an entity as either a data fiduciary or a data processor. At that time, nobody thought about the possibility that certain processes can be a data fiduciary processes, certain processes can be a data processor kind of processes, where no decision is taken on the purpose or means. There is one department of an organization just processes it on behalf of another department. So in that case, there could be an internal data fiduciary and internal data processor. So it is possible that when we bifurcate the whole organization to multiple processes, some processes will be tagged as data fiduciary processes, some may not be. And even in that, some processes may be called significant data fiduciary processes, some may not be. And some data fiduciary processes may have another external data fiduciary. It will be a joint data fiduciary process, whereas in some other case, there may be no other external person. So these distinctions can be captured when you are talking of attacking the compliance requirements of an organization at different process levels. So this we consider as one of the key principles of DGPSI. You may say that even in the case of GDPR, we can create what is called the record of processing activities. And here, this what we call as a register of processing activities, we create an inventory of processes. Within that inventory, we build the inventory of data, etc. And we feel that this is a better way of dealing with the compliance, rather than looking at the entire enterprise and trying to run a software to, for example, even discovery of data. Now, if you want to discover the legacy data, which is part of our requirement of DPDPA for compliance, I have to find out where all the personal data is held in my organization. I have to identify the purpose for which I am processing it today, and then send an appropriate privacy notice, collect the consent. All this I have to do for the millions of personal data sets which I may be already having. Now, by dividing this process into multiple classifications, multiple processes, I am trying to identify a process owner, and that process owner will have the better visibility on what data he is processing, and therefore we feel that even creating a data inventory becomes more reliable when it is done by the process owner rather than by some vague software which is just doing a search process in the entire organization based on some parameters we define, and try to extract something and say this is personal data, because that software may find it difficult to make a distinction between GDPR data and Indian data. Whereas when we are talking of a process, the process owner clearly knows that whether he is processing GDPR data or he is processing Indian data. So if there is one process in which GDPR data is being processed, that person will be trying to comply with GDPR, whereas the person who is managing the process of Indian data will try to focus on DPDPA. So that kind of distinction also becomes possible. So we are recommending the process-based approach very strongly. The second key principle is about the classification. When we talk of classifying the personal data, now the ISMS classifies the personal data into a limited 4 or 5 categories. But here we are trying to classify the data in such a manner that the compliance becomes easy. So tomorrow after classification, if I have to assign some controls, the controls are based on what the law requires, and that has to be applied to a certain category of personal data. For example, if there's a control for minors data, it is not applicable to adult data. It is applicable only to minors data. So if I have the classification of data as adult data, minors data, employees data, and so on, it becomes easy for me to be compliant. So we classify the data keeping the compliance requirements of DPDPA, and in fact, we have arrived at totally, including non-personal data and personal data, totally 31 classifications for data in an organization, starting with data being first classified as non-personal and personal, and in personal, the DPDPA protected data and others. And then in DPDPA protected data, we go into further bifurcation where some exemptions are available in some data for which legitimate use can be used, some data in which consent is to be taken, in some data for which this parental consent has to be taken. So like that, we try to subdivide the data into multiple classifications, and that will help in later on having the compliance being automated tomorrow if you want to automate. Now, because of these things, the entity becomes a hybrid entity. It will have a data processor processes, data fiduciary processes, significant data fiduciary. So it is as if the company is wearing multiple hats at the same time. So it is, in terms of organization, it is possible to put all the significant data fiduciary processes in one particular high security zone and put your DPO in that particular location, so that there is better control over the significant data fiduciary processes of this organization. So there is some thought process in that. And the other principle which follows this is what is called distributed responsibility. What we mean here is that instead of picking up one person DPO and say that you are responsible for all the million data which I am processing, we have already said process owners will be appointed. The process owner will be considered as a deputy DPO or something like that for his process. And in fact, we feel that every employee of an organization is a DPO within his sphere of influence. And that is the concept of distributed responsibility we try to recommend. Okay. Now, ultimately, all these frameworks becomes recommendations, and some of the recommendations the companies may accept, some they may not. It is open to them to see the value and then take a decision. Similarly, another important principle we adopt is data has a monetary value and that has to be recognized. And if possible, it has to be brought into the balance sheet also. Okay, how to value it and other things is something which we have to work out. And of course, in FDPPA, we have already started working on that. We have got something called Data Valuation Standard of India. We have put some thoughts into it, and later on the industry has to work out a proper method so that at least in the balance sheet, not in the main profit sharing figures, but as a footnote, we can say that my company has got, say, 1,000 crores worth of personal data. Now, how to value that is part of a discussion at some other time. Now, another key principle is measurability. We want the maturity of implementation to be measurable, and that is where the DTS concept comes in. Then in terms of HR, we always feel that there are whistleblowers, but whistleblowers should not be restricted to the employees. We consider that any person from outside who points out some errors in mistakes in our company, they are also whistleblowers, and even our bug bounty program is linked to that. Then we feel that top management should hold the responsibility, and that is why we have got this deviation justification document, which is signed off by the top management, so that they know what risk they are absorbing. Principle number 9 is that the compliance should start from the business level, not at the technology level. The marketing manager who is negotiating a new contract, he should incorporate the DPDPA compliance at the discussions. So therefore, if he wants to charge a little more because the compliance costs in a particular project, he should be aware of. So the business level approach instead of technology level approach or even a DPO level approach. We don't want a marketing manager to bring some business and tell the DPO, manage your privacy risk in whatever manner you want. We want that to be done by the CMO himself. Okay. Documentation is integral. Why we make a specific statement of this is we are talking of legal compliance. So whatever you do, tomorrow it may become a subject matter of a court litigation. Therefore, documentation is integral to the compliance much more than in a business best practice related compliance. Security is, of course, essential. The confidentiality, integrity, and availability concept applies here also, but here we apply it to the personal data. Okay, whereas the CISO is responsible for the entire data. Then last principle is the motivation of people is fundamental to the policy implementation. We believe that unless a culture is created in the organization, whatever else we do in terms of policies and technology is meaningless. So that is one of the key principles. So these are the 12 key principles under which DGPSI is built. Now, before we go into the implementation specifications, I will also cover the 6 foundation principles we have adopted for the DGPSI AI. Remember that we are talking of the data fiduciary who is using AI or any of the data processors supporting the data fiduciary is using AI. The core principles of this DGPSI AI is recognition of a significant risk, accountability, explainability, responsibility, security, and ethics. I will explain briefly what it means because these are all new concepts. There are no other India-specific AI guidelines as of this particular moment. The committee only said that it has to be developed. They were not aware that it has already been developed. So I am only presenting what has already been developed. The first principle here is that AI presents an unknown risk. The behavior of AI, as we see from the recent incidents of Sydney, Replit, Cursor AI, and other this thing, even DeepSeek, okay, we know that these AIs, particularly those which are supported by LLM, are open to a hallucination risk. When sometimes we require creativity, particularly when we are using the LLM for some creative work like writing, authoring some text, or say creating images. But in a deterministic application where we as lawyers or the DPOs are interested in, we do not want the DPO, the AI, to be creative enough to assume something which is not relevant for DPDPA. We all know that how AIs have been creating case laws and presenting it to the courts as if they exist. So if in future it is possible that AIs can take a GDPR principle and put it as DPDPA principle, or pick up something from Colorado AI and put it here. So the risk of an AI going rogue and exhibiting hallucination is very, very realistic, and there does not appear to be a proper way of mitigating an unknown risk. So if a risk is unknown and it cannot be mitigated, the data fiduciary, by being a fiduciary as a trustee, is unable to actually protect the beneficiary, and therefore wherever AI is being used, we say that that should be considered as an unknown risk. Unknown risk is a significant risk, and the data fiduciary which is holding the significant risk should be considered as a significant data fiduciary. This is the principle which we are recommending, which means that AI usage will make every data fiduciary into a significant data fiduciary, because anyway you do not know what the AI is going to turn out. Now, I'm not saying AI should not be used, but the having taken a decision to use AI, the user should take the responsibility and call himself a significant data fiduciary and put in necessary guardrails as may be required. Now, as far as accountability is concerned, AI recognizes that there has to be a human oversight, and we feel that being a legal compliance requirement, every AI should have an associated human handler who should be legally liable for the activities of the AI. So we feel that every AI algorithm has to be associated with an individual human being. Now, government had once said that this has to be hard-coded into the particular algorithm itself. We still talk about it in the synthetic content management in the Information Technology Act, intermediary liability. When synthetic content is generated, the origin of that has to be noted by a watermark or something like that. Same thing we are talking of as accountability, but we don't want this accountability to stop at a company. An individual should be held responsible. He may be ultimately the AI coder, because he is the person who is responsible for wrong coding of an AI, which could result in problems. Explainability is another requirement. See, after all, a data fiduciary, when he writes a privacy notice, he is supposed to explain how he is processing the data. So explainability is built in the DPDPA provision of privacy notice to be understandable, clear, etc., and also explainable. So while he is taking the explainability responsibility for privacy notice, he should also remember that if there is no explainability for the AI which he is using, there is no meaning in his privacy notice. Therefore, explainability is a requirement which the data fiduciary should ensure in the privacy notice, and back to back, he should ensure that there is an explainability document submitted by the developer also. Next principle is responsibility. What we mean by responsibility here is a data fiduciary should not jump in to use AI just because it is fancy. He should make a document saying that why this data AI is required for my processing, and why not using it will be perhaps not a good thing for the business. So there has to be a documentation of why a data fiduciary wants to use AI despite the unpredictable risks, despite making him significant data fiduciary. That is one of the principles. Security obviously is essential like any other software. there has to be reasonable security. What is reasonable in the context of AI may be different. Apart from confidentiality, integrity, and availability of information, which is the normal requirement of any software. In case the AI is designed to take some autonomous decisions, there could be some higher level of security requirement. And where there is a humanoid robo or an industrial robo where the arms are metallic or kind of a thing, there could be also physical risks associated with it. Many of you are aware that one of the chess playing robo actually broke the finger of his opponent because he made a wrong move and this robo caught his finger and broke. There are cases in the industrial robo situation where people suspect that there was some misuse leading to death of a person or something like that. As we build more and more intelligent humanoid robots, and there are companies which are making them the CEOs, there are governments which are making them the ministers, and in this world, there is a possibility that physical harm, mental harm can be caused by the use of AI, and the security principle takes that into account. Last is the ethics. When we mention ethics, we are admitting that everything cannot be put down into a law. Therefore, we expect somebody to do something for the benefit of the society, even if that is not hard-coded. So we feel that use of AI should also follow that ethics. So these 12 plus 6 principles guide us in the DGPSI. I feel that there is no other framework in India or maybe anywhere else which has addressed this requirement in this particular manner. But I must admit that we are all aware that these frameworks are under development. We are inviting the professionals to suggest if any changes are required, improvements are required. We are ready to look at that. But we feel that whatever has already been done is something which is momentous in terms of work. And I think it will be a good guideline to follow even for the government. Government should follow what we are doing, because this is something which is having the input from people who are having years of experience in the particular field. It is not that we are a private company, government is the government, and government should not listen to us. We feel that government should listen to us. After all, we are the citizens of the country. We are interested in the government and the country much more, or at least as much as anybody else. People who know me personally, they know that I speak more like a government person many times. So that is inherent in our approach. Now, with these principles, I will briefly try to make some information about how the implementation specifications are structured. I will perhaps skip some of these things. Once you understand how the implementation specifications are structured, then we will have some time for discussions and questions. Okay. Now, DGPSI Lite, I told you, is a simplified version. It has got 36 implementation specification. Each implementation specification reads something like this: establish the legal basis, develop appropriate notices, or something like that. Each one of these is linked to a particular section in the DPDPA, so that we are in this 36 implementation specifications, we are covering all the compliance requirements of the Act. Of course, this only gives the top line of what needs to be done, and the consultant who is implementing it will have to develop the documents which address this. For example, we are saying that if a company wants to make use a process for legitimate under a legitimate use concept, we say that there should be a legitimate use policy. So when we are dividing the organization's work into multiple processes, and there is one process in which the process owner says, I don't need consent for this because it comes under legitimate use. then I need a legitimate use policy to support that particular process. For example, if you say employment, processing of personal data for employment purposes comes under legitimate use. Processing of personal data for medical emergencies comes under legitimate use. So there is a process for employment relation, processing, a process for handling medical emergencies. In these processes, there will be no need for a consent, but there will be a policy document called legitimate use policy for process 1, legitimate use policy for process 2, and such legitimate use policies have to be endorsed by the legal department of the organization. Similarly, there may be some processing which may fall under exemptions under section 17 of the DPDPA. There also we expect that there is a written policy, and exemption policy should be approved by the board of the organization. So every process will have either a supportive legitimate use policy or it will have a exemption policy, failing which it will fall back on consent. That sort of things are included in the description of the implementation specifications under this. This notice should be available in 22 languages. It should be, consent should be free. You should have procedure for using consents received from a consent manager, and prospective data to be properly tagged, legacy data to be properly updated with consent. Each one of that, section by section, there is a list. So if you go through this 36 these things, you will have a summary of the requirements of this particular DPDPA. So this DGPSI Lite is built like this. It is directly related to the legal provisions, except that you may have to do some interpretations. For example, verifiable consent, what it means. Okay, the rules have come. It's not fully, again, cleared one aspect. Now, remember that if you want to take verifiable consent from a parent, you should first of all identify that the data principal is a minor. Now, you cannot go by a self-declaration by a person who says, I am not a minor. So every data principal has to first go through a filtering process that this person is not a minor. If he becomes a minor, then we should ask who is your guardian and then try to take his consent. Now, this sort of some additional interpretation may be required. Otherwise, the DGPSI Lite may say that verifiable parental consent should be obtained. In the case of SDF, also there is one more this thing. If an organization is an SDF, there is a significant data fiduciary, there are certain requirements to be done. Now, who will be declaring an organization as an SDF? Government may, but government may not. So every organization should have a self-evaluation of its own activity and declare itself as SDF or not an SDF. So we say there should be a policy for that. These kind of things are covered in the list mentioned here, totally 36 implementation specifications. Okay, this entire DGPSI is considered as an open source framework. In two books, one is DGPSI, another DGPSI Lite. All these details are available, plus some explanations are available. So at a cost of say around 800 rupees, which is the cost of one ISO document sold by the at the concessional rate by the Indian BIS, you will be getting the complete set of implementation specifications with some guidelines. One of the problems which we have with ISO is if there is one implementation of ISO, I need to read 10 ISO documents. Each document costs 5,000, 8,000 rupees if you want to actually get an official copy. I have always been telling that if there is a law or if there is a best practice, government should ensure that people should not pay for knowing what is good for this to be done. So ideally, all these standards should be free. And that's why we said that this DGPSI will be an open source. Only the implementation part, people can make money through appropriate consultancy. Now we will come to the DGPSI full, which has got 50 specifications. Here, what we have done is this 50 implementation specifications have been bifurcated into 5 responsibility centers: management, DPO, legal, HR, and technology. So management will have 15 implementation specifications for which they are held responsible. DPO is responsible for 17. Technology is responsible only for 8 of the 50 implementation specifications. This bifurcation, we are using it also for the DTS calculations because the weightages may vary. Again, here I will not go through the entire 50 specifications. I will just give you the indication. For example, the first implementation specification is organization shall designate a DPO. Second is organization shall constitute a data governance committee. So organization shall appoint a data auditor where required. So that kind of a thing is what contained here. Some of these things have to be done by the management. See, there are certain things which are not perhaps easily seen in other things. For example, one of the implementation specification is that organization should establish an exception handling, because whatever else we do, there will be occasions when you have to have an exception, and how the exceptions will be handled, reported, managed is one of the policies. Distributed responsibility will affect your HR policy. Therefore, management has to take a decision. Then some of the other, this one, identify the financial value of the data is again a management decision. Then system for factoring in new business prospecting, because we say that DGPSI starts from the business level. Then managing the third-party contractors policy is also at the managerial level. And then organization shall establish a system for managing relationship with certain and other regulatory agencies. These sort of responsibilities are kept at the management level because the DPO also may not be able to take decisions on these things. Now, then DPO will have most of the normal operational requirements like creating policies, etc. Most of the other frameworks focus only on these responsibilities of the DPO. Then we feel that legal should also have some responsibilities. For example, this nomination facility. Now, I feel that it is the responsibility of the legal department to create a nomination methodology. Similarly, grievance redressal is something the legal department has to do. Then contracts of the contractors will have to be vetted. So there are certain things which will be the responsibility of the legal department. HR department has got their own responsibilities, including the whistleblower policy, I already said. Then comes the technology, which will have the responsibilities for creating inventory of data, inventory of processes, then classification, having a centralized database with a master data identity. Now, the DPDPA rules expects that every consent will have to have a unique serial number. Now, so technology will have to do all those things. Okay, so this is how the 50 implementation specifications are distributed. I would request you to please go through the FAQ, which may be there in the FDPPI website, or you purchase those books which are available in Kindle form also. Then the details will be available. So for SMEs, DGPSI Lite should be considered sufficient. For others, I think they should go for this DGPSI full. I will take only a few more minutes to just cover the DGPSI AI specifications before we go into a question and answer session. Okay, the implementation specification following that principle I already said will be something like this. For example, the deployer of an AI software in the capacity of a data fiduciary shall document a risk assessment of the software. There is a separate DPIA required when AI is being used. Okay, and it will be periodically augmented with external data auditors evaluation. And because it's an unknown risk, we are considering it as a significant risk. Otherwise, you create a AI deviation justification document. Okay, that is the specification. Now, designate a specific human handler. Okay, and document the human handler for AI on behalf of the licensor, that is transferor, also as part of the contract. Then explainability document has to be submitted by the developer to the user. It will be the responsibility of the licensor or transferor. Then as far as responsibility is concerned, there should be a document to say that I need to use AI, without which I will be at a disadvantage. So that kind of a documentation, AI justification document, is part of the implementation specification. Then as far as security is concerned, one, we expect the developer to give us an assurance certificate that AI software is adequately tested at their end for vulnerabilities, preferably from a third-party auditor. And there should be a statement to say when deployed for data processing, this AI software is reasonably secured against vulnerabilities that may be adversely affect the confidentiality, integrity, etc. So that kind of an assurance, like what you see in the EU AI Act, okay, is part of this. So that is where I say that we have actually included the best practices from other, frameworks. It could be ISO 42001, it could be the EU AI Act itself, but the best things are found here. But ultimately, for the user, there is one framework to be followed, not 100 frameworks to be followed. Now, the document should also mention sufficient guardrails exist, and then give a kind of instruction on how the guardrails have to be perhaps configured at the user's end. And in terms of ethics, we feel that there has to be an appropriate kill switch in every AI software, and I hope technically it is feasible. The kill switch has to be in a circuit independent of the circuit which manages the robo itself, particularly humanoid robots, because we don't want the robots to interfere with the kill switch. Say in the case of Replit and other things, what we have found is that when the user tried to invoke the kill switch, the software refused to take the instructions and continued its rogue behavior. It only happens if the kill switch is in the same circuit as the main operational this thing, and the two works together. So this is a technical issue. Maybe I am not the best person to give a view on this, but we can say that as a user, I want this to be done. It is for the technology people to make it possible. So these are the main implementation specifications. But if you want on the developer side, we have got about 13 implementation specifications, which includes the explainability, accountability through human handler, this training and testing process, and risk assessment, guardrails, and default configuration being documented and conveyed to the licensee. Then the incorporation of emergency handling instructions, kill switch. So all these things are part of the developer's risk management requirements. In fact, if there is a critical risk, such as we feel could be there in a cyborg kind of a situation where the autonomy given is very high, probably should be branded as a critical risk. Now, how this can be handled in practice, it will be part of our implementation process. I hope at some point of time we will be able to explain that in any particular situation. Okay, so I will now stop at this particular point, and now I look forward to any questions so that in the next 10-15 minutes we can spend on discussing the questions. Okay. I'm sorry I went through a little fast because the time available required that. Okay. So now the floor is open to you.
Good evening, sir. This is Srivatsa. Hope you are able to hear me.
Yeah, I'm able to hear you. Yeah.
Yeah, sir, you mentioned about SME's version of DGPSI
Yeah.
Lite. I want to understand if this light version will be applicable across different verticals of SMEs, the small industries basically, because in small industries we have from everything from salt maker to an AI kind of a manufacturer. So does it cover all the aspects here across the verticals?
See, the law itself is across all sectors. Okay, DPDPA is something which cuts across all industry types and also all sizes of the organization. As of now, they have not given any exemptions to on industry basis or size basis. So obviously, the compliance also will cut across all these things. Where there could be differences is in the risk assessment. If we find that a particular implementation specification, the risk probability and the impact is low, then the organization may absorb that risk and avoid a investment in covering that kind of a implementation specification. So it is still covered, but it in when we create this adapted implementation specification, that is there is the occasion on which an organization can document why a particular thing can be further simplified, because in their industry, the way they are using it, the risk for this particular aspect is not very high. Of course, we will have a separate risk register, but I hope you got the point that the law does not make a distinction. So DGPSI also cannot make a distinction, but at the time of implementation, we can bring in some flexibility. All that flexibility will result in absorbed risks. Okay, where the auditor is not going to say that you will not have a risk. We will say that that risk, the organization has agreed to absorb that risk. Now, the auditor and you can discuss and say how big is the risk, what is the impact level, and what is the probability level, and then decide that, okay, this much of risk I will set aside, I will take some kind of a liability insurance if necessary, whatever is that, that is how it has to be handled. Shivatsa, it's okay?
Yeah, thank you.
Yeah.
If I can ask one more question, sir, this is
Yeah.
regarding the fine that has been proposed by the government
Yeah.
as a policy. It is indicating as high as 250 crore rupees in case of non-conformance or non-compliance. So how exactly are they looking at SMEs in this case, sir? Because their
No,
business itself may not be into
no, I understand. You see, we don't have to say that in every case 250 crores will be applied. In fact, as you know, that the penalty table also says that it is up to so and so. Okay, so therefore it is not required. And secondly, the DPP is there to uh, perhaps take that decision of what should be the penalty. They may put only 1 lakh for a particular company, or they may allow voluntary undertaking in the first say violation. Only if the violations are repeating, or if they feel that the organization is completely neglecting, then they may start imposing the penalty. It is not that every particular case only 250 crores or 200 crores or whatever is mentioned will be levied. In fact, I believe that DPP will be very, very soft on the industry, and SMEs also will be part of that. But you have to come together, have an SME organization created, and see that you are able to properly respond to such things. For example, you may not be able to afford appointing a DPO who is really worth being a DPO. But okay, today DPO skills are so scarce that you will not be able to recruit a DPO if by paying 2 lakhs, 3 lakhs per month or something like that. So therefore, you have to ensure that you still have access to the advice, but the law expects that DPO has to be an employee. So you have to designate one of your existing employees as DPO, but retain an external consultant to ensure that you are having the access to the best advice. This can be done at the industry level in terms of your associations and others, and thereby individual SMEs which are small can definitely be protected. I have been a banker earlier. We have worked with small scale industries, single man companies, micro enterprises. The law here is same for everybody. Even an individual who processes personal data for business purpose is called a data fiduciary. Okay, a State Bank of India is on par with a cooperative bank. So the law is made for everybody together, and definitely DPB will take into account and then ensure that people are not put off. So you don't have to be unduly worried at this point of time. Yeah.
Good evening, sir.
Thank you.
Yeah.
Yeah, good evening, sir. Prabhu here.
Yeah.
Sir, one small question. For those companies who have like GCC kind of setup, right? Like they have headquartered in US and then other subsidiary or private limited company in India, and they do not collect any of the data of any Indian citizens other than the employees.
Yeah.
So what happens? Does it apply? It applies. What is the steps?
Say DPDPA applies to the data generated from India of Indian people. Okay. It may also add the data of foreigners who are in India. That is a small portion of it. DPDPA does not apply to the US data or some other data which is being processed by the GCC. So what this particular act does is, if you have such a situation, you can get your data center or operational center notified to be exempt from DPDPA provisions. Okay, so you can do that. But one thing you have to remember, that if the data center commits some fraud or something of that which falls into the area of cyber crimes, ITA 2000 does not give you the exemption. DPDPA provides you the exemption. So if you are having a GCC or any operations, even a GDPR contractor, you are a data processor for a data controller and processing the data in India. Say in GDPR, if you are processing the data in the EU countries, you have to follow GDPR, even though the data itself is not of EU citizens, but it is of Indian citizens. But Indian law, the government has recognized that this is unfair, and they have said that by notification, you can exempt that particular data center or operational center from the operations of DPDPA. Of course, this particular lawmakers did not have the power to make changes in ITA 2000, but so ITA 2000 they have not touched. But in ITA 2000, if it applies to all people, including Indians, non-Indians, whatever is that, therefore, if some terrorist activity goes on in some data which is being processed, let us say by a GCC, then under ITA 2000, they may have some right to question, but not under DPDPA. Okay?
Thank you, sir.
Naavi sir,
Yeah.
right
Yeah,
now,
tell me.
do anyone want to have a look at the DGPSI and DGPSI AI and DGPSI meaning? From where they can become this the document?
Say, first of all, these books are now available in Amazon and Kindle. So it's already public. And you know that we have distributed it to the extent possible, many times even free. In fact, our IDPS Bangalore, 100 plus books on this DGPSI AI was distributed free. And there is a FAQ on DGPSI also available. And the one straight source is you just buy off even the Kindle version. It doesn't cost much, 300 rupees for DGPSI and maybe around the same thing for the DGPSI AI. Plus, of course, we are also offering discounts if anybody asks directly the FDPPI. You are aware of that. In many of the training programs, we have distributed it free also. But otherwise, it's available in the marketplace as a book. This book contains these details, plus explanations and other things. So it is much more than buying a specification of an ISO kind of a thing. Okay.
Sir, Satish here. I have a question.
Yeah.
Good evening, sir.
Good evening, sir. Are you able to hear me?
Jagannathan.
Yeah, one of you first, Satish, and then Jagan. Yeah, Satish.
Sir, November 13th, this DPDPA rules were published. Now, they have told a few things with immediate effect. Now, just what I wanted to know is whatever is there as an immediate effect, it is nothing for the organization, right? It is for an organization, we have time till November 2026 or something for the consent management part and all those things, right? Is my understanding right?
Correct. The first, that's why we were thinking, why was the necessity for the government to delay these rules for so long? Okay, now what is required now is to form the data protection board. They wanted to define the salary of this thing or put a search committee in place and select the chairperson. The only new thing they have said is we will have 4 persons as the members of the data protection board, and it will be located in the NCR. These are the things which were not there in the act. They have added. Okay, industry is not bothered where it is. Anyway, they are going to operate like a digital office. So initially, DPP has to come into operation. They have to set up a website. In the website, they have to make provisions for various things, including notifications, communication with the people and other things. They have to form certain committees, one committee for the helping the government departments about how to determine the data retention, and one committee which may take a view on classification of significant data, fiduciary, and so on. So there are certain internal things which they have to do. After 1 year, they will start receiving registration applications for consent managers. So if somebody wants to make an application to be a consent manager on November 13, 2026, they should finish their preparations like setting up the platform, getting it audited, and be ready to apply on November 2026. Rest of the things will only be coming into effect in May 2027, 18 months from today. So by that time, you should be ready. The penalties may start applying by that time. So you don't want to be exposed to a notice from the DPB immediately. So in this 1.5 years, I feel you should try to put your systems in place, test your systems in place, and be ready with the compliance much before that deadline of May 13th, 2027. Okay. So nothing else is to be done, but the preparatory time, my own experience in handling a few of these audits so far is that nothing comes fast. Okay, nothing happens in an organization for 6 months, and now most of the time the software also is not easily available. So they need this entire 1.5 years they will require for preparation. So I feel that company should start working on gap analysis immediately, identify the gaps, try to put in place one by one the implementation.
Thank you, sir. Thank you.
Yeah. Yeah, Jagan. Yeah.
Yeah. Good evening. You mentioned that the DGPSI takes care of all the requirements of DPDPA. Does it take care of the requirements of DPDPR also? Specifically, DPDPR. Specifically, Rule 6 has certain very specific
if
technical requirements.
You are talking of DPDPR means DPDP rules, is it?
Correct. So the Rule 6, DPDP rules.
It does cover that, because rules are subordinate to the act. So we prepare everything based on the act, we knowing fully well that government cannot say something in the rules which is not there in the act. If they say something which is not there in the act, then there will be somebody who will go to the court and say that these rules are ultra vires the act and beat down the whole act. So we knew that rules cannot override the act. DGPSI covers the act, and as far as the finer things of rules are concerned, it is in the development of the policy and other things. So it does cover the rules. There is no problem. We are ahead of the government in that respect?
Yeah, I wouldn't say it overrides rules override the act, but there are certain very specific which are not there in the act. In the rule, they have brought in certain very specific requirements, related but very
Give me some
specified.
example. Give me an example.
Like Section 6, they brought in very specifically the technical safeguards which were not there mentioned so much in DPDPA.
No. In the
DPDPA,
draft,
they just mentioned the safeguards.
no, wait.
Yeah.
There was draft rules which were submitted, published in January 2025. We have conducted several training programs on the draft rules. These safeguards you are talking of, I think, rule number 6. Okay.
Rule 6,
It does,
yeah.
Rule 6. It was there in the draft rules also.
Yeah.
Okay. Say, earlier there were 22 rules, now it has become 23. Why? Because that rule on verifiable consent, they have bifurcated minors data and the other one. That legal liability guardian provision, that is the only thing which is actually completely new. But if you look at our DGPSI, we already said there that DGPSI perfect prescription for DPDPA compliance. And we said it is a cyber jurisprudential document, which means that we tried to interpret some of the aspects that this is the best way to do it. Government was perhaps not fully ready, and now for example, verifiable consent. Now, where from you will verify whether a person is a major or a minor? You should ask every data principal, what is your age? Otherwise, he should have some system like a age pass or something like that. Now, those are the systems which are not fully in place. We had already taken this into account and said that somebody has to develop this age verification software and other things. There are people who are saying that looking at the face, I can determine the age. We have always said that no, it's not possible, because we need to distinguish between 17 years, 6 months and 18 years, 6 months. It's not that whether Vijay Shankar is a major or a minor. That you can, looking at the face, you can decide. So there are many face recognition software which are calling themselves as age verification softwares. Okay, we have always said that no, that is not feasible. We have therefore looked at interpreting the act and trying to give the prescription. And now some of those things are clarified and it will continue. Even after the DPB comes into existence, but remember, all policy documents will come not from the DPB, it will come directly from the ministry. There will be new explanations, advisories which will be given, and that process will go on. I think next 1 year, there will be a lot of things like that which will be happening. We at FDPPI have to keep chasing the changes and then perhaps try our best to bring out the details. In fact, after our recent training at Bombay, I suggested that we will be having an SIG for DPDPA rules. I think Somsekhar is here. So Somsekhar was one of the persons who was there. And we have actually suggested that we will have one special interest group of FDPPI looking at DPDPA rules. And that interest group will look at this, whatever questions you are having today, and sectoral difficulties and other things, and trying to place it before the DPB. Another SIG will look at the tools. So both we are trying to do. And maybe Mr. Somsekhar will be heading one of those SIGs also. Of course, me and Ramesh will be helping them, but we will continue to monitor what changes will happen in the rules and what changes should happen. Both we are trying to do. Yeah, Sudarshan.
Good evening, sir. We are having our own lead auditor training program for 27701.
Yeah.
One of the trainers suggested that we should have at the end of the booklet one comparison table of 27701 and the FDPPA standard, no?
Yes.
DPSI. So
yeah.
When we do that, is it required to make a reference to you then? Or I have bought the book just now, both the books, what you suggested. Just now I bought on Amazon.
Mm.
So
No,
can we publish on our own? Is it
you
okay?
can publish, you please make a mention, that's okay. It's open source, I told you, no? It's an open
Okay.
source, we don't mind. But
Ah.
if you refer, we will be happy. Okay.
Yeah, we'll give you a website reference. If you permit us,
Yeah.
we give you your mobile number also.
Sudarshan
Yeah,
sir.
yeah.
Okay. Okay.
Sudarshan sir, if I can request you, you can even invite us for half an hour one slot. My Naavi sir can talk about it. That will also be interesting in your program.
That's correct. That's correct. That's also a good idea.
Yeah, yeah.
We
Because
do
that
that.
will
We
be
do that. In fact, we invite practitioners to come and talk.
absolutely. I am
Yeah,
aware. I know you. I know the way
Yeah.
you conduct normally,
Yeah.
right? You accommodate. So I would
Yeah.
suggest that probably you
Yeah,
can
we'll do that.
give
Okay.
us a slot.
Okay. Okay.
Naavi
Okay.
sir, we will.
Yeah,
we will
definitely.
present
No,
this.
no problem at all.
Great.
Sudarshan is also our supporting
Correct.
member actually. So
Correct.
he
No,
is
but the only issue is we will have members from other countries also in the
Absolutely,
participants.
absolutely,
no
absolutely.
problem. Say we are
Okay.
okay. I say the DGPSI is an indication of how it has been approached here.
Yeah, okay.
I feel that tomorrow you can roll out versions of DGPSI for GDPR and other things also. Anyway, that is for the future. I am not focusing on that. Let them also know that something is being done here. That's
correct. So somewhere in mid-December, I'll contact you for this.
Super.
Okay.
Yeah.
Thank you. Thank you.
Great, sir. Thank you very much.
Yeah, friends, I have no time constraint. It's already past 8, but if you have questions, I am still willing to answer it. Don't worry. If you otherwise, we'll think about it. Yeah, any other questions? Mr. Sanjay Sharma, any questions?
Did they finally approve any data protection authority in India?
No, this data protection board will be the one which will be similar to the data protection authority, supervisory authorities in other cases.
But
Data
have they already
protection board.
Selected somebody?
We don't know. It could have been informal, but formally they are first putting up a search committee. First, they have to choose a chairperson. For that, the search committee will have the cabinet secretary. Members will be the IT secretary and law secretary will be also there. After that, there will be a separate committee for selection of these 4 members. Obviously, at the government level, they would already have identified somebody. We don't know. But that process will take another 1 month or 2 months, perhaps.
Yeah, but what about the state level? Will they also appoint?
There will be no state level this thing. There is only all India level. There will be a data protection board. They will operate mostly on virtual basis. That is in the sense that there will be a website. You can contact them on that. So, for example, today TDSAT is also sitting in Delhi only. In fact, we originally suggested Cyber Appellate Tribunal should have benches in South India. It was not done. And when now TDSAT is there now, most of the courts are trying to do virtual hearings. So they are trying to make it easy. And here it is there in the rules also. In the rules itself, they have mentioned it will operate through a digital office. What it means is that in most of the cases, they will be handling it through virtual contacts.
But Delhi-based department.
It is NCR. NCR they have stated. So they have not stated Delhi, but they have said NCR. I don't know. They may put it somewhere there.
But people are leaving NCR because of pollution. They are moving to the.
True. We had actually suggested it should be in Bangalore. No, we said actually it should be in Bangalore, and we were talking to Tejasvi Surya and others, Rajiv Chandrasekhar, when they were there. But anyway, it is a very high power committee, so it has to be in Delhi. Okay.
Okay. Oh, thank you.
Yeah. Yeah. Anybody else? Prasad?
Nothing, sir.
So
there's another question from me. Regarding the protection of the rights of say individuals or the companies, is there any platform that is already represented in these rules? For example, if there is a non-compliance and a government or the authority levies a heavy fine, and eventually they figure out that it's not such a big compliance, non-compliance, and they have a way of contesting that or a mechanism to contest the non-compliance?
Now it is there. The Data Protection Board will give an opportunity to hear out the other side. They will not take unilateral decisions. Your lawyer or your DPO can go there, discuss it, and present yourself. It will be like any tribunal's activity. And from there, appeal can be taken to TDSAT also. From Data Protection Board, it will go to TDSAT. From TDSAT, it will go to Supreme Court. So that at any of these points, you can try to put through your defense and try to get the penalties reduced or eliminated.
Thank you.
So the grievance redressal mechanism starts with as far as the data principal is concerned, there has to be a grievance redressal mechanism at the company level. Now, after that, if the data principal is not satisfied, he will just drop an email to the Data Protection Board as a complaint. He himself will have to go to the ITA 2000 adjudicator for claiming compensation. Now, once the complaint reaches the Data Protection Board, they will conduct an inquiry on the company. At that time, they will send you a show cause notice. And then you can give your reply to that show cause notice. If they are not satisfied, then they will say that we will perhaps have a hearing and take a view on the penalty. At that time, you have to involve your lawyers. That is where lawyers will have to be capable of handling this kind of litigation. They should know the corporate these things, and they also should know how to handle these. Of course, DPB chairperson and others, they are not judges. Okay, so at that level, DPO can himself handle. Like I have handled many cases of adjudication where the adjudicator was IT secretary in Information Technology Act. Though I was not a lawyer, I was able to successfully handle that. Cyber Appellate Tribunal also I was able to represent, that it is said. But when it goes from there to High Court or something like that, it becomes a bit legalistic. So at the TDSAT level or later at Supreme Court level, you need assistance of a litigation lawyer who is also aware of DPDPA. Don't go to a lawyer just because he is having good real estate practice or something like that. You have to choose a